Assume everyone is ready from our side of the table.
Just so we all get an understanding of what the licensed midwife can do. This is taken directly from statute so that we all can get kind of grounded on what we're talking about. The license to practice midwifery authorizes the holder, under the supervision of a licensed physician surgeon, which I think is, we just kind of talked about that issue in the prior item, to attend cases of normal childbirth and to provide prenatal, intrapartum, and postpartum care, including family planning care for the mother and immediate care of the newborn. So again, as my colleague has pointed out, that's what essentially the scope of practice is right there. Not exactly the same thing as medicine. It's differentiated because it's set out in statute.
Given ACOG's changed position paper, which supports a collaborative relationship, it seemed like the time was right to try to bring this issue forth again. Although we haven't been successful, the board hasn't been successful in the past. And the board does, as a regulatory body, have a certain responsibility, not for the civil liability aspect of it, but to try to make sure that the law works and can be followed by the people who are licensed and are required to comply with it. It's very difficult if there is a catch-22 to make sure that the public is protected and that the license functions can be performed as the legislature contemplated. So that was really the reason for the language that you see in front of you. It is derived in part from the ACOG position statement and from other states' laws as well.
So for to start out with is for the physician surgeon supervision for the licensed midwives. As you just previously heard, that they basically are not able to comply with that law with the way things have been working out. But they're required to have it in order to practice, and we have come up with what we think might be a solution to that problem, which is physician collaboration. And so we have drafted some draft language that would allow that to happen, but at the last MAC meeting we did not have any physicians attending, so we do not have any physician input on what we have drafted. And so what we're asking is for the board to consider the draft language that we've looked at, but also to authorize us to do a interested parties meeting so that we get the physicians' input on it to see what we need to do to maybe modify it or make it acceptable. For sure that we would have that ability to make it go forward and actually be useful for the midwives. If we start the regulation process without collaboration of the physicians for what their input is, we would get that during the regulatory hearing process and have to usually start over, which is a much more lengthy process, which we're trying to avoid.
Mr. Hepler, you advise me, please tell me.
Thank you, Madam President. From this side, you get to see everybody's full face, not just their profile from what I said up there. So, candidly, although I'm sitting here, this effort is really the fine work of Ms. Scurry. And what collectively we tried to do was form this in a more collaborative relationship, taking kind of a different spin on it than the traditional supervision requirement. And so that's what you see before you. I just want to comment that you will take public comment, but as an administrative board, I just want to remind everybody that civil liability is not really our forte. We leave that to the judicial system. Administrative discipline and that sort of thing is our forte, and we take our actions based upon the imprimatur of public protection. So thank you.
I think the issue has been currently is that there are certain legal issues that do not allow this group of individuals to do what they have been trained to do, and one of them is even in the situation of having to have a woman go to the hospital because an emergency has arisen. The hospital may not take the patient in. That there's a liability issue, and that there's, I think that what we have to recognize is that this committee has been meeting. There's been a lot of frustration. It's been fraught with arguments and discussion. What we have are identified 2 or 3 specific issues that if those issues were dealt with in an official, appropriate manner, that maybe this would be an issue that we could then figure out what is going on. And to that extent, an interested parties meeting, which is what you're suggesting you have, would be the opportunity you would hear from this board as well, but you would hear from those people that are engaged and involved in that. And that's what your staff recommendation is on this, is to have an interested parties meeting to go forward and to move it forward. Questions?
Well, I thank God not an OBGYN to be caught in this moral dilemma, but it would seem to me that at the table needs to be an attorney, a lot of attorneys, but certainly for the malpractice carriers to see how they would interpret collaboration, to see.
That's what an interested parties meeting is about.
Let's not be vague. Let's be specific. Attorneys to make sure, because a physician can feel this is a good thing, want to do the right thing, but they can't lose their malpractice coverage.
Dr. Diego?
You know, I do have a comment type of question. I don't know that we have the answer to it. And there is the malpractice and all that and the high liability, and that's where everyone gets stuck, right? But if that were taken away, I wonder if the OBGYNs would still be interested. I mean, I don't know that if you guys have gone off and explored that, because right now they can say very nice things and say, oh, I'd love to, but malpractice, blah, blah, blah. But deep inside, would they? I mean, are we then going to come back and have a different set of problem?
Okay. Dr. Spelman?
I appreciate Carlos's comment, and that kind of is my thought, which is if we're saying midwifery is not the practice of medicine, and I respect that, then I would think we do not need physician supervision. And I think we should work towards, it's that we don't supervise the pharmacist. So why should we supervise the midwife? I think they should have autonomy, and I would push for that.
Dr. Levine?
Yeah, I really appreciate the spirit of this effort to find a way through the dilemma that exists. And my only question about the language is that there is a big difference between agreeing to provide guidance and instructions regarding the care of women and or newborns and agreeing to provide emergency advice should complications develop. And that, to me, isn't an informal collaborative relationship. So it seems to me that binds the physician to being available should emergency complications develop, particularly if there is only one such collaborative agreement. And I'm wondering what the intent of that is, because that language suggests something other than informal collaborative relationship.
They just dare not.
This is an issue that has been on the table for a long time, and we doctors feel that the malpractice issue is a serious issue, and at this moment, really, many doctors will want to cooperate with the midwives, especially in areas, for example, in the area that I work. But it's extremely difficult. The insurance carrier doesn't give you the green light to do that, and that's something very serious.
Just thank you very much, Dr. Ganadev.
I have the same concern. I'm not an OBGYN, I'm a surgeon, but the professional liability issue for the birth or a bad baby syndrome is a serious issue. I want to emphasize that. That's where I am the medical director of a public hospital, and the highest settlements are on that note compared to anything else. So I think we got to be very careful here. Protection of the consumers, and that's the reason why physicians often don't. And there might be some other reasons in their mind, business related, but in my mind, I think that's a big reason what OBGYN people I met with told me, as it wasn't a personal experience because I'm not one.
Would you like for me to make a comment here?
Oh, no, please make a comment.
This comment is colored greatly by personal experience with a total disaster with a midwife who had an informal relationship with a physician in my small town. And they were caring for a patient in a large town. However, when complications did arise, they transported the patient 60 miles.
Your microphone is not in front of you. They
Large
can't.
town to the small town. The baby did badly, and everyone was sued except for the nurse, for not even nurse, but the midwife. It's really colored my opinion, so I have to tell you that up front. But I'm extremely concerned because of the informal relationship. I believe there's a matter in front of the board currently as well regarding the supervision of people in plastic surgery centers who are doing Botox and things like that. And that's of great concern to the board, and I think this should be as well.
Okay.
Are any of the other allied health professionals in California legally able to obtain prescription drugs? Nurse practitioners, PAs?
Yes.
Yes, both counsel to the Physician Assistant Committee. They don't call them prescriptions. They do call them drug orders. And with the proper delegation of services agreement between the supervising physician and the PA, the PA.
Supervising physician.
And the
These
PA.
individuals do not have supervising physicians, correct?
Not in the same sense that a PA
Correct, they
does.
do not.
Correct.
Okay. Would nurse midwife training include the same pharmacologic training and skills as a nurse practitioner and or a PA?
So let's understand the
They're not
question.
nurse
The
midwives,
question
they're
you're
midwives.
asking, Dr. Bishop, are there other allied professionals who are trained, allowed to receive materials that allow them to do their job appropriately?
Well, I'm asking prescription medications in the absence of a physician's prescription.
Are you asking prescriptions? I don't think that,
That's the crux of the matter.
but that's not what's being asked for here.
Well, it is. Because you can, if all of a sudden you say it's within their scope of practice to do anything, then they obviate all the rules that we have in place for prescription drug administration. See, I'm telling you, this nebulous discussion is opening a door to unintended consequences.
Anita?
They should not be utilizing prescription medications in the absence of correct pharmacologic training that's commensurate with other professionals,
Anita?
is my opinion.
Well, you're not, it's your opinion. But we're trying to get questions
There-
answered
there-
about this.
Physicians' assistants and nurse practitioners, when they are utilizing drug orders or whatever you like to call them, your prescriptive power, do have a supervising physician, but then they are performing medical tasks. Midwifery is a separate type of practice that is not a part of medicine. I mean, that's hard to comprehend that, that's the way it's set up in the law as a separate type. This proposal does not allow unfettered access. It is the authority limited to the practice of midwifery to obtain and administer these particular drugs, immunizing agents, diagnostic tests, and services for which they are, in fact, trained in their 3-year program.
I would argue if you're administering drugs and caring for patients, that's the practice of medicine. I think we're talking a definition here that I don't agree with. Should be subject to the same requirements that all other allied health professionals are subject to. I think we're trying to get around, as Dr. Yanadev said, legislating a law with a kind of a end around.